Good afternoon, everyone, and welcome to the Admiral Security Services webinar on the Patient Protection and Affordable Care Act. My name is Holly Miller, and I will be the moderator for today's meeting. Presenting today, we have Bill McIntyre, Managing Principal Consultant with USI, with over 25 years' experience in the employee benefits area, and Richard Seiden, Benefits Counsel with USI, who has over 35 years of experience in the regulatory and compliance area. We anticipate today's presentation to last approximately 45 minutes, and we will have a brief period at the end to answer questions. Please be sure to type any questions that you may have during the presentation. Richard, I will turn it over to you now to begin the presentation.
Good afternoon, everybody, and welcome. So if we could move to the next slide, we are going to take a brief tour through the current state of healthcare reform, where we have come from, where we are now, and what's left ahead of us, so that you can understand the burdens and obligations of employers in conforming to this law in terms of their healthcare plans and the impact it will have on you in your relations with Admiral. And after I take you through the legal aspects of healthcare reform, we will be talking, and Bill will join and take you through the direct impact on all of you. So we're looking at highlights here of the timeline, which began in 2010. I think most of you are familiar with the journey we've been on as we move forward to full implementation in 2014 and beyond. If we can have the next slide. So where we are right now, as current as we can be, is the beginning of the state and federally run exchange process. We finally have guidance on what employers need to provide their employees in terms of information about the exchanges that will be set up by the various states, and in some cases, as you will hear me talk about in a bit, by the federal government, where states have declined to do that. These are the marketplaces. They're now called health insurance marketplaces, that where carriers will come and offer coverages for employees and individuals to buy so that more people can have access to affordable care. We don't know what the exchanges will look like yet in most cases. There's only a few that have been fleshed out, California most recently. But we are looking at the beginning process. The beginning process is that employers must notify their employees of the availability of the exchanges and how they will work and where employees can go to find out about this. And we have model templates from the government and a deadline of October 1st, and for all new hires beginning October 1st, and thereafter to get this exchange notice. Now, as I indicated, we don't have a lot of substantive information about how the exchanges will work or what they will look like state to state, but this is a very generic form that alerts employees to the process. It is a burden on the employer to provide this notice to their employees. Next slide, please. So in 2014, there are a whole slew, if I can use that term, of requirements that come into effect under healthcare reform that affect how employers function with respect to their employee benefits and how individuals function under the new scheme. There are new fees being imposed upon, significant fees being imposed upon employer-provided plans in order to fund the transition to this exchange model in the 51 jurisdictions, including the District of Columbia. New patient protections, the imposition of an individual mandate. I'm sure most of you had some familiarity with that in the Supreme Court decision last year that requires Healthy Lives to buy coverage in order to broaden the risk pool. The development of the exchanges and small group exchanges in the states where people can go to buy coverage, subsidies from the federal government to help lower-income people buy coverage, additional reporting obligations in order to make this whole structure work significant taxes that will be imposed upon the health insurance industry to help finance the infrastructure of the full rollout of healthcare reform, and additional burdens on employers moving forward to 2014 and beyond in terms of automatic enrollment to make sure that employer plans are fully subscribed, and wellness program incentives, which will become more favorable for employers to try to encourage healthy lifestyles. Final rules were just issued today. I haven't read them yet, but we've seen the proposed rules, and we don't expect too many surprises. This will enable employers to incent employees to take steps to improve their health, which is sort of the underlying real motivation for cost increases in addition to the penalties and fees that will be imposed. Next slide, please. So the transitional reinsurance program fee is a significant $63 per person fee that will be imposed upon all plans, insured and self-insured, beginning in 2014. I say $63 per person. We're talking about not just the employee, but the employee's dependents and the employee's spouse. That's $63 times the total headcount of the plan. We're talking about a expected cost increase larger than 1 to 2% for many plans. Significant cost driver for employer-provided plans will be used to provide funding for how the state exchanges, as they're developed, will work. If you can go to the next slide, please. There is also a health insurance tax, which starts at $8.3 billion in 2000. I said billion dollars. $8.3 billion in 2014, increasing over $11 billion in 2015, and moving upward thereafter, which is intended to help to provide funding for the overall cost of implementing healthcare reform, because healthcare reform, in addition to the exchanges and the government involvement and the interaction of employers and employees and taxes and penalties, has a huge infrastructure to it. So the health insurance industry, the health insurance carriers, will be imposed this fee. This fee will be imposed upon them. Under the law, there is no requirement that they eat, if you will, this cost. They will pass it on to their book of business. So their book of business, for our purposes, is all of the employer plans that are insured by these carriers, and so the fee will be apportioned to the carriers based upon that premium written, and they will trickle down that cost to the plans that they insure. We're looking at another 1.9 to 2.3% cost increase for insured plans, in addition to the $63 fee, which will generate 1 or 2 points. So you're talking about here maybe upwards of 5% cost increase that doesn't have anything to do with what we call medical trend or claims experience. This is the environment that employers are finding themselves in. Now, this particular tax or fee does not apply to self-funded plans or to stop-loss insurance as it's currently understood, and it is likely to be a stimulus or incentive for employers to look at self-funding as a way of funding plans as opposed to insurance, because of the significant cost savings that might be available. If I can go to the next slide, please. There will also be a complicated, I say complicated because I don't know anything the IRS does that's simple, reporting structure that will develop information between the exchanges, the IRS, these are the state exchanges, the IRS, which is enforcing the employer penalties, and the employers, in order to determine whether the employers are providing the right level of coverage to avoid penalty, whether the people who are receiving subsidies under the exchanges are entitled to the subsidies, and whether they will trigger penalties against the employers by getting the subsidy. And that infrastructure will add to the cost of running these plans, additional administrative costs to insurance carriers, significant administrative burdens to employers. Unclear how this will all roll out yet. We're waiting for guidance. And in fact, to be very frank with you, we're almost at June 1 of 2013. 4 months away from the October 1 open enrollment period for the exchanges, 6 months away from the full rollout and implementation of healthcare reform, and we are woefully deficient in the amount of guidance we have in terms of how all of this is going to work. And so concern on people like my part as to how to help people, employers, cope with the emerging responsibilities. We just don't have enough answers, and there's not a whole lot of time left to figure this all out. So don't mean to scare you, but that's the environment we're living in. If we can go to the next slide. So beginning in 2014, plans will all need to address plan design changes that go into effect beginning in 2014 regarding pre-existing condition exclusions, a tightening of the allowable waiting periods to 90 days, the elimination of annual limits, clinical trials, restrictions on cost-sharing limits, and these are all going to result in reevaluation of programs, plan changes, analysis of costs of these changes and their impact on other provisions. So we will be busy as well. Next slide, please. So beginning in 2014, this is part of the structure and the objective of healthcare reform, which is to provide access to greater care at an affordable level for uninsured Americans, is the concept that healthy Americans who weren't buying coverage and weren't participating in insured programs, individual or group, need to find coverage and need to pay premium into the insurance risk pool so that the risk is spread not just to sick lives but to all adult Americans, to enable the carriers to then be able to go to these state exchanges that are set up and offer affordable coverage at better rates than they currently are, their argument being that they're only insuring sick lives. That's why it's so expensive. So the individual mandate is intended to address that. But as you can see, the penalties are small, even in 2016 and beyond, but certainly in 2014 and 2015. The penalties are small so that any 30-year-old healthy individual who isn't buying coverage because they don't want to spend the thousands of dollars is not going to be penalized enough to make it a financial incentive for them to buy coverage. The result of them not buying coverage will be contrary to the objective of developing affordable rates by the carriers. So a big question mark here as to whether this aspect of the law will reach its intended objective and accomplish affordable rates by the carriers. So if I can go to the next slide. And I want you to hold that thought because when I get to some information about the exchanges, I'm going to tie that back in. So in addition, there's a certain element or level of coverage that an individual must buy so that there's meaningful participation in the risk pool. So employer plan, an individual health plan, a government-sponsored health plan, because lower-income people will be eligible for Medicaid and so on. So if you're under 30, you can buy a catastrophic health plan. Over 30, you've got to buy something more meaningful. This is all an intent to get healthy lives into their risk pool, so to speak. Think of it as, for those of you who are familiar with states with no-fault automobile insurance, it's very expensive because they'll take anybody. But if the only people, if they weren't forced to do that by law, if the only people they were getting for insurance were poor drivers, the rates would go sky high. The idea is to get a blended pool of safe drivers and not safe drivers, healthy lives in the health insurance business and non-health and sick people. Next slide, please. So part of this whole structure is what we now call the health insurance marketplace. We've been calling them exchanges under healthcare reform since 2010, but now we have to call them by their new name, health insurance marketplaces. The concept here is that an exchange will be set up in each state, and plus the District of Columbia, which will act as a marketplace for carriers to come and provide their offerings of affordable health care for individuals who don't have coverage elsewhere who want to buy it. It also triggers into how the employer penalties will work, because people who go to the exchanges, lower income people who don't have adequate affordable coverage from their employer, will trigger penalties against the employer. You see, that's another part of the structure. The issue here is, what will these state exchanges, marketplaces look like? They will be different from state to state. Many states have declined, and they're allowed to do that under the law, to develop and run an exchange. The default in the law is if the state doesn't do it, the federal government does, and so we're looking at significant number of states where the federal government is going to have to build an exchange, and in significant number of states where they're still working on constructing exchanges. If I can go to the next slide. Initial enrollment for people who want to take advantage of the marketplaces, the exchanges, is supposed to begin on October 1, 2013, for enrollment by December 22nd, 2013 for January 1 coverage, with employers providing employee communication prior to October 1. That is a very aggressive timeline given the state of development of the exchanges or marketplaces so far. One of the reasons why some government officials, even in the administration's camp, have been talking about a potential train wreck, and that's their term, not mine. So if we can go to the next slide. So as you can see here, and this is just briefly, the orange states are states that have declined to establish exchanges. And I said to the federal government, there'll be no state-developed exchange in my state. You'll have to come in and build one. And the blue states shown here are states that are actively working on developing their own exchange. California announced their offerings and prices last week. Interestingly, California's prices are very moderate for coverage, but of the 4 major carriers that are nationally the largest carriers, Cigna, United Healthcare, the network of the Blue Cross Blue Shield companies, and Aetna, only the Blues participating in these. There's 13 carriers participating in the exchange in California, but only the Blues of the major carriers, Cigna, United, and Aetna, declined to participate. Whether that will be a pattern we see in the other states, we don't know. We also don't know which states will have fully enrollable models as opposed to just providing links to the participating carriers, or whether what kind of offerings or pricing will exist. The light-colored states, the few handful of light-colored states in this chart, are states that say we do want to build an exchange. We want to be responsible for an exchange, but we don't know how to do it. So we will partner with you, the federal government. You'll come in and help build it for us. So you see here, if you look at these colors, that that the federal government is responsible for building some 33 exchanges, none of which are developed yet, and yet we are just 4 months away from October 1 enrollment. I don't have an answer to the question that you would ask about how that's going to work. So let's go to the next slide. So lower income people between 100 and 400% of the federal poverty level, who don't have affordable or what we call minimum value, good enough or cheap enough coverage from their employer. The other side of that is that the employer doesn't provide that, they expose themselves to penalty. If someone's under 400% of the federal poverty level and doesn't have that good enough, affordable enough coverage, they will get federal tax credits and subsidies on the exchanges, whether they're a federal exchange or a state exchange, to buy coverage on that exchange. The coverage is not going to be free. It's a sliding scale depending on income, but there will be significant subsidization of the individual's cost of coverage for people under 400% of the federal poverty level. Now, for 2000, if we can go to the next slide. So for 2014, the 400% of the federal poverty level will be somewhere in the neighborhood of $46,000 for a single person. So anybody under that number can get a subsidy and can trigger an employer penalty. Interestingly, if that person has a family of 4, but for the safe harbors we'll talk about in a minute, that number, 400% of the federal poverty level, is 92,200, maybe higher in 2014. So anybody, the people making in the low to mid-90s could still get federal subsidies under the exchanges and still be a penalty trigger, but for the safe harbors we'll talk about. Next slide, please. So there's a lot of people who will be eligible for federal help on the exchanges. Federal help translates into cost. Cost translates into burden somewhere. Insurance carrier taxes, the penalties on employers, somewhere that money has to be developed. So the cost-sharing subsidy under the exchanges will be available to individuals between 100 and 250% of the federal poverty level who meet certain other criteria. And these are, in addition to the subsidy to buy coverage, will be a reduction in the cost-sharing provisions in a particular program, deductibles, copays, out-of-pocket costs, and so on. So if we can go to the next. So here's how it works for employers. No employer has to provide coverage under healthcare reform. There's no mandate. If an employer doesn't provide coverage to employees or doesn't provide coverage that is good enough under the standards that are developing or affordable enough, will be exposed to penalties under healthcare reform. So in some cases, the penalties will be cheaper than the cost of providing the coverage, which gets into the discussion of dropping coverage and paying the penalty. But as we know, employers provide coverage, healthcare coverage, for reasons that go well beyond the actual cost. So there's 2 levels of penalty. One is if you offer no coverage, and the other is if you offer a level of coverage, but it's not good enough or affordable enough. So employers will be either looking at paying, just taking the penalty, or as we call playing. These are the terms that have been assigned to that. Playing means to offer some level of healthcare coverage to substantially all full-time employees and affordable and minimum value coverage to full-time employees in order to avoid the penalties. So in our situation, Admiral has chosen to structure programs for its employees, full-time employees, that will not incur penalties. These programs will develop some cost obligation on the part of Admiral, and Bill will be talking later about how that impacts you. So if we can go to the next slide, please. So we've talked, and there's lots of intricacies in the detail here, but what you need to know is that the employer penalty provisions, the shared responsibility provision, applies to large employers, employers with 50 or more full-time employees. For this test and this test only, part-timers are fractionalized and added up, and the evaluation is made based across all companies under common control. So Admiral, under these rules, is a large employer and is faced with the issue of understanding the impact of the penalty provisions and making a choice to pay or play. Next slide, please. So for 2014, additional costs to employers like Admiral is there are employees who are currently not covered who will enroll in an employer's health plan under this new universe of design, and that has to be compared with what's available to those people under other in other places like the exchanges, and what the penalty evaluation will be versus the cost of insurance. And so, in addition, you can measure that by looking at a safe harbor, which we'll talk about a little more detail of 9.5% of W-2 income. But basically, employers are looking at measuring the potential additional costs against the potential penalties for complying with or for meeting the healthcare reform safe harbors. Next slide, please. Can I have the next slide? So you start off with providing some level of coverage. We're not sure how that's fully defined yet, to 95% of all your employees. If you do that as an employer, then you have to look at, if you don't, then you're going to get hit with the penalty of 2,000 times everybody, which is significant penalty, but usually less than what it costs per employee to provide coverage. But even if you provide some level of coverage to substantially all your employees, you're still looking at another evaluation. Is the plan a minimum value plan? A minimum value plan is a plan that will cover 60% of anticipated costs on the average. That's what we call in the exchanges a bronze level plan, although subsidies under the exchanges will be provided for silver level plans, plans that are where their combination of coinsurance deductibles, out-of-pockets, and everything are expected to meet 70% of all costs. So if you provide a 60% plan and you take advantage of the safe harbor that allows you to look at the cost of buying single coverage compared to the employee's W-2. The employee's cost of single coverage compared to the employee's W-2, that doesn't exceed 9.5% of the employee's W-2, and the plan's a 60% plan. There is no penalty exposure regardless of what the employee does. The employee can't get a subsidy if they have a safe harbor offer. They could buy on the exchange at full price, but the employer will not have a penalty. And that's a significant safe harbor. It also does not restrict you from charging more for dependent coverage, nor do you have to provide coverage to spouses in order to take advantage of the safe harbor. That's pretty strange in my book, based on my experience. So Admiral's plan will be affordable under the safe harbor and will provide a 60% or more minimum value. Next slide, please. So as I said, the W-2 safe harbor, and it has some alternatives for hourly employees and salaried employees using a monthly salary. Look solely at the lowest level plan based upon the employee cost for the lowest level single coverage, measured against the W-2 or the hourly rate times 130 or the monthly salary, and there's alternatives to determine whether that employee cost exceeds 9.5% of the W-2 or the hourly rate of the monthly salary. If it doesn't, then that's a W-2 safe harbor. That coverage is affordable regardless of what the employer charges for dependent coverage and whether or not they provide coverage to spouses. And that eliminates the risk of the $3,000 penalty. But it does require that the employer offer coverage at an affordable price, which is a cost factor in and of itself. Next slide, please. So for these purposes, we're talking about full-time employees. And full-time employees generally defined as averaging 30 hours a week. Now, it's easy to say that. The ability to determine whether someone is a full-time employee or not often gets confusing when people are working variable hours or working seasonal or part-time, and there are methodologies that the rules give us, very complicated ones. But basically, we're looking at people who are 30-hour-a-week employees, and it doesn't matter what the employer calls them. So they can be called independent contractors or employees. The question is, whose common law employee are they? Who controls their employment in terms of employment, training, retention, and so on? And the hours will not only be hours for which the employee is paid to work, but hours paid for time off, leave of absence, vacation, etc. Next slide, please. So when you have regular full-time employees and they're scheduled to work at least 30 hours a week, not a big deal. You know you're dealing with them and you have to offer them the coverage. Continuing employees or new hires. But as I said, there will be some employees where the hours may vary on a month-to-month basis, or it cannot be expected reasonably that they will work on average at least 30 hours a week, or in many cases seasonal employees. And then you get fairly complicated measuring methodologies to determine whether someone is a full-time employee, which allows you to keep those employees out while you measure them, but once they meet the measurement requirement, they're in for a whole year regardless of how their hours work out. So next slide, please. So what we see here is typically high-tech companies, financial companies, legal environments, employees are regularly scheduled 30 hours a week or more. There's no variation in hours. If you don't bring them in within 90 days, then they become a penalty exposure for you. But there are other industries, retail, restaurants, hospitality, agriculture, resorts, where people are either variable hours, they're called in as needed, their hours vary from week to week or month to month, or there's real seasonality. And in those cases, you often will not be able to determine at the get-go whether someone's a full-time employee. There you get the ability to measure them for up to 12 months and fix their eligibility for the next plan year based upon that measurement. Even if they, so you get a chance to keep them out, but if they turn out in the coverage period to drop to a lower hour standard, they're still in for that coverage period. Go to the next slide. And I just wanted to mention to the Admiral that to meet the 90-day requirement for full-time employees, we'll be providing coverage as of the first of the month following 60 days, because you can no longer use a 90-day in first of the month. They have to be covered on the 91st day. The only way to ensure that is to go and keep a first of the month entry is to use a 60-day measure. So I'm just going to show you this. I'm not going to try to explain this in detail, but for variable hour people and newly hired people, for ongoing and newly hired people for whom hours are variable or who have seasonality in their employment, you have an initial measurement period, for a new employee, a standard measurement period. For ongoing employees, a brief up to 90-day administrative period to figure out the numbers, and then a plan year or coverage period that called the stability period, which is the coverage period or plan year, for which those who meet the tests within the measurement period are in for the entire coming plan year. Now, this will allow you to keep an employer to keep many employees out who are seasonal or variable, but will end up having to provide coverage to some employees for a coming plan year where their numbers change so that they wouldn't otherwise be eligible. Next slide, please. Now, behind that slide, by the way, is pages and pages of regulation and methodologies and examples that will vary from situation to situation. So, variable hour employees and special leave. If you're measuring employees and you're crediting, counting hours in the measurement period, there is special treatment for FMLA and military leave and jury duty that give the benefit of the doubt to the employee and give them some credit continuation for periods during which they're on these accepted, recognized special leaves. Next slide, please. So the other aspect to this is you can no longer just say when someone leaves, I can disregard all their hours before their leave date, before their departure date. As in the pension arena, you will have to take into account hours worked before the break in service, so to speak, under circumstances which favor the employee. If we can go to the next slide. So if you rehire someone or someone comes back to work with you, if the break is at least 26 consecutive weeks with no hours, then you can disregard the prior service in determining whether they're a full-time employee. But, and you can also use a smaller break period of less than 26 weeks, but at least 4 weeks, but you can only disregard if the period of break is longer than the previous period of employment. So this gives you some ability to disregard service, but it also protects the employee who leaves and comes back. And this only applies in the variable hour and seasonal situations, because otherwise, if you're scheduled as a regularly full-time employee, you're either in or you're a penalty trigger to an employer. So next slide, please. So here's the fun part. we're trying to talk about impacts and with specificity, and we have lots of areas of guidance that are needed. The areas that Senator Baucus of Montana described to the government officials as desperately needing guidance, and the absence of guidance raising the significant potential for, as he described it, and the words he used, a train wreck. We have lots of unknowns in the full-time 30-hour calculation of employees in various different scenarios: commissioned employees, adjunct faculty, Service Contract Act employees, employees who work under contracts with the federal government, who get fringe equivalents as part of the Service Contract Act, which is a federal law, and we don't know whether that will be enough to be meaningful coverage, even though it's dictated by another federal statute. There are issues remaining over collectively bargained plans, Taft-Hartley plans. There's been some guidance, but there's still the burden still belongs to the employer. The employer has to be responsible for whether the union's plan is good enough or affordable enough. Temporary staffing agencies and other staffing agencies raise significant questions for the administration of these rules. We are awaiting as sort of an added burden, significant anti-discrimination rules, discrimination in favor of highly compensated, which will be imposed on fully insured plans. At some point in time, the rules have been delayed, but will significantly burden employers in terms of finding out whether their plans are operating in accordance with these rules, because the failure penalty is draconian. It's $100 a day for every participant who doesn't get the benefit that's deemed discriminatory. You're talking tens to hundreds of thousands of dollars and maybe more for potential violations of a rule that has mysteries to it still. So we still need to know a whole lot more about how the exchanges are going to work and how the employer penalty provisions are going to work. But we are where we are, and no one is backing away from pointing at the starting gate on January 1, 2014, so we have to do the best we can. Now, how this all impacts employers and customers like you, Bill will begin to discuss those issues with you. Bill?
Okay, thank you, Richard. Thank you, Richard. Now, before we talk about strategies that employers are implementing, let's recap what Admiral's strategy is going to be. First off, Admiral is going to play. That is, they are going to offer a bronze level plan to 95% of all employees and their dependents. That plan will be affordable. That means it will cost no more than 9.5% of an employee's W-2 earnings. And finally, the plan will be compliant with all of healthcare reform mandated patient protections. Now, what are some strategies that employers are considering and in some cases already implementing? The first strategy that's probably gotten the most press since healthcare reform was passed in 2010 has been the restructuring of the work hours. As most of you probably have seen in the news over the past several years, many fast food chains and retail establishments have gone out and said that they will restructure work hours so that they will minimize the number of employees who work 30 or more hours and therefore have to be covered under healthcare reform. We'll talk just in a couple of minutes about some of the downfall to that approach. And in fact, you're seeing many of those same industries now, 2 or 3 years later, that have come out and said, you know, that's actually not such a good idea after all. Another idea is to reduce benefits. Most employer-sponsored plans are at what's known as a gold or silver metallic level. In order to have a minimum value plan under healthcare reform, you must have a bronze level plan. That is a plan that pays 60% of healthcare costs. So if employers are going to have to cover more employees as a result of healthcare reform, then what they'll do is they'll ratchet down the benefits from a gold or silver plan down to a bronze plan. Another strategy is to base contributions on the lowest cost plan. That is, structure the contributions based upon your lowest, say, your bronze plan, and then may still offer the additional richer benefits, but make them 100% employee buy-up. Cost mitigation strategies. If you're looking to reduce costs, again, because you have to cover more employees as a result of healthcare reform, then you're going to look for other ways that you could save money, such as, for example, self-funding. Now, under self-funding, not only can you avoid the 2+% for the health insurance tax, but you can avoid a lot of the other risk charges and things that are embedded, other costs that are embedded in the typical fully insured medical premium. Population health management strategies, another word for wellness. So again, a lot of corporations are taking a second look at wellness, especially in light of the proposed wellness incentives, as a way to help keep their costs down. Defined contribution approach is an approach very similar to what employers went to 15 to 20 years ago when they shifted from the defined benefit pension plan to the defined contribution. Very similar in that the employer gives the employee a fixed amount of money, and then the employee decides what benefits they're going to purchase with that money, and then any additional benefits they want, they would pay for out of their own pocket. Private insurance exchange is an insurance exchange that's like the public exchange, only it's for private employers, in that it offers the employees much more choice than they currently have now. Now, when structuring benefits and contributions, employers are looking to shift a lot of the contributions towards the single coverage, because under healthcare reform, to be deemed affordable, the lowest plan that meets minimum value must not cost the employee more than 9.5% of their W-2 earnings. So therefore, in order to meet that, a lot of employers are shifting their contribution away from some of the family tiers and moving it towards the single tier in order to make sure that their plan at least is affordable for all employees. Now, when doing these contribution strategies, employers also need to be mindful of the anti-selection that's created with this. That is, under healthcare reform, employees are going to be coming in, employees are going to be coming out. So to the extent possible, the employer wants to make sure that they mitigate any anti-selection by making sure that those employees are coming in are the younger, healthier, and if you are going to lose employees, lose the older, less healthy employees. Now, another solution is to set contributions on a sliding scale so that the contribution is affordable for all employees. Now, there is one solution that is gained a lot of traction lately. In fact, it was introduced to the public last week in an article in the Wall Street Journal, and that's the bare bones medical plans. Now, you're going to hear a lot about this if you haven't already in the next week or two. So I would like to bring Richard back on the phone and have him speak about this just for a couple of minutes.
So I'm sorry, Bill, I had a little bit of a break up there. If you could rephrase
Yeah,
that.
we're just the bare bones medical plans. If you could just speak to that just for a minute or so.
So look, let me say this to you. We are a free enterprise economy, and what that means to us is that if there is a need, there will be people who are trying to fill that need. And employers are looking at what it will take to provide minimum essential coverage to their employees in order to move down from the $2,000 times everybody penalty to the transactional $3,000 times a person. And there are people in the marketplace who are trying to answer that question right now in ways that are innovative, but it's not clear that they will be the results that will meet the test. So the ones we're seeing now are people who are trying to structure preventive-only plans with stop-loss insurance, really no treatment reimbursement, and trying to structure them so that sign up with us as we get more guidance. We will have these plans in place for you, and you'll be safe from the $2,000 penalty. And that may very well be. The problem is that the government will eventually issue its wisdom on what minimum essential coverage is, and everyone will know that, and then we will all find the most effective, reasonable, cost-effective methodologies for accomplishing that. And to me, this is my view, it's a personal view, and Bill and I have had lots of discussions on this, it's premature to look at anything that's described as a bare bones medical plan as something that will work or might even work. We will know what works when we know what works, and at that point in time, lots of people will be looking to help us to develop those kinds of programs. I don't fault the people who are marketing them now. I just think, to me, it's premature and somewhat illogical that a preventive-only plan could satisfy minimum essential coverage requirements when mini-med plans and limited medical plans are being outlawed by this very same law. Bill?
Thank you, Richard. Right. Thank you, Richard. And also, in regards to that, if you do have a bare bones plan, you may be able to avoid the $2,000 penalty, but you may not be able to avoid the $3,000 unaffordable penalty if an employee goes to the insurance exchange and by virtue of their income is able to qualify for a subsidy. Now, what will the impact on healthcare reform have on the clients? Well, first off, contract costs will increase because now you're having to provide medical coverage for more employees that currently have it now. But with this additional benefit, you're going to find that there's going to be a reduction in turnover and potential increase in workforce stability. Therefore, a stable workforce equals a better staff and better service. Now, what will this coverage cost the employees? Well, we don't know for sure what it's going to cost the employer, but we do know that Admiral is committed to maintaining benefits in accordance with the law, which means it will not cost the employees more than 9.5% of their income. So based upon that regulation, we can back into what it will cost on maximum for each employee based upon the safe harbor. So for example, an individual who makes $7.25 per hour will pay no more than $89.53 a month for their insurance coverage. Each hourly increase enables the employer to increase their contribution. So, for example, thus someone making $12 an hour can pay $148.20 a month and still have what's known as affordable health care coverage. That is, health care coverage that's no more than 9.5% of their W-2 earnings. Now, full-time versus part-time. There's been a lot of discussion about companies moving their workforce from full-time to part-time in order to avoid the health care reform costs. As I mentioned before, a lot of the national fast food and retail chains 2 or 3 years ago were screaming from the mountaintops that they were not going to have full-time employees anymore. I think a lot of those very same companies have backed down when they realized the other hidden costs associated with moving from a workforce that's primarily based on full-time to one that's based on part-time. And in fact, a recent report issued by ASIS stated that such moves will result in unintended consequences. Well, what are some of those consequences? Well, staffing accounts with part-time staff could cause serious operational concerns and could severely compromise quality. Now, how will clients be charged? Well, there's 2 methods that can be used to charge clients. First off is the preferred method, which is the hourly billing rate. Under this method, the cost associated with the additional medical coverage is already included in your monthly billing rate, your hourly billing rate. This method is the simplest for the clients in that it will eliminate any time for reconciliation purposes. However, there's an alternate approach, which is the direct billing approach. And under this approach, Admiral would bill the clients directly for the costs associated with the medical care. Now, under this approach, there would be an additional fee because there would be additional administrative time and invoice time on Admiral's part, but there would also be an additional time imposed on you, the clients, in order to administer this and to reconcile the monthly bill. So definitely the way to go in this is the hourly billing rate. Now, how do we know that your service provider could administer this benefit? Well, besides the cost associated with the new law, the issue of administration is foremost in everyone's minds, especially because under healthcare reform, there are a lot of moving parts to this. And all clients want to make sure that their administrator can administer the plan in accordance with the law. And with Admiral, there are no such worries there because, in fact, Admiral has been successfully administering employee benefits for more than 50 years. And during that 50-year tenure, they've been partnering with one of the largest brokerage firms in the United States. And Admiral only partners with reputable medical insurance firms, no discount medical plan providers. And finally, the Admiral Corporate Benefits team currently manages plans for over 5,000 employees that work in several states. Additional plan participants will be no issue for Admiral.
Thank you, Richard and Bill. I think we have time to answer a couple of questions from the group. Richard, the first question that we have is, it is my understanding that employers that elect to play and offer insurance must make dependent coverage available, but there is no requirement to subsidize dependent coverage. Is that accurate?
So this is Richard. Yes, that is accurate. There is a requirement, and it's muted in 2014, but there is a requirement for the various safe harbors to offer a level of dependent coverage, but there is no requirement as to how the employer has to fund that level of dependent coverage.
Okay. Okay. The second question that we have is, it seems that a company who elects to pay and not offer a plan, pay the annual penalty, can do so cheaper than if they offered coverage. Why won't most employers simply pay the penalties in this case?
Well, there are hidden costs for not offering a plan, and employers don't offer health care coverage strictly based on the cost. Turnover, retention, attraction of employees, workforce stability. So all of these mitigate in favor of employers providing coverage. And, we have a long employee relations history of benefits being part of compensation. Employers are not going to move away from that without serious thought and consideration.
Okay, good. Next we have, I believe many employees do not realize they can be charged a percentage to pay for their health care. Is that the feeling within the industry, and what effect do you believe this will have on participation?
Well, that's right now the question that's foremost in everybody's minds as we speak to employers. The impact of the subsidies and the employee cost on their employer plans will all come into play significantly for lower wage earners. And it may very well be that lower wage earners can buy insurance in an exchange, a state exchange or a federal exchange, cheaper than they can buy from their employer, especially if they need family coverage, because employers, as we're talking about, may not provide much funding for family coverage. There are also, higher wage earners are paying a small amount in many cases or nothing for their health coverage. So there may be significant increases in cost sharing for this group as well to help offset the expense of providing coverage for low wage earners. But much of this will depend on how employers respond to, in terms of plan design and costing, for penalty purposes, as well as what's going to be offered under the state exchanges and how that will be priced.
Okay, I think we have time for one last question, and that is, how does this law affect the contract with the union?
So there's still some guidance yet to come under this, but the employee in question, for penalty purposes, belongs to the employer and not to the union. So but we know that if the union plan, which I'm going to Taft-Hartley Trust, is providing coverage that's affordable and of minimum value to the employee, that employee's employer can take credit for that and will satisfy the requirements for avoiding penalty. The unanswered question, the one that needs more guidance and the one they're studying, is what happens where an employer is contributing an hourly rate and the coverage offered to the employee will always be minimum value. I've never seen a Taft-Hartley plan that wasn't, but is too costly to be affordable, and the employer really doesn't have control over that. So we need some guidance and maybe some relief for employers that are under collective bargaining agreements in those situations.
Okay, thank you for those clarifications. We'd like to wrap it up now and to thank everyone attending today for their time and attention. If you do have any further questions or comments, you can send them to webinar@admiralsecurity.com. Please also note that Admiral will be hosting this webinar on their website soon. Thank you again, and have a nice afternoon.